Please be seated. The court is now back in session. I hand over the floor to the defense team for Mr. Nguyen Chia to resume your comments or observation on the key documents presented by the co-prosecutors and lead co-lawyers for the civil parties. You may proceed.
Thank you, Mr. President. I've been told that I'm going much too fast for the translators to keep up, so I suppose I do have to slow down. And if I go too fast, I hopefully will be hearing that. Mr. President, Your Honors, before the break, I concluded my one-by-one discussion of the prosecution's documents in relation to the JCE policy on enemies. But to complete our response, these documents, of course, must be placed in a greater context. The statements about so-called enemies made by or on behalf of the CPK leaders are no different from the rhetoric routinely used by world leaders everywhere. The idea that the CPK had a policy of killing enemies is something like saying that every state which has an army has a policy of war. Protecting its government and its citizens against internal and external enemies is part of the core function of what states do. If you allow me, and I'll be very brief, Mr. President, on this, but if you allow me, let us look at some examples. In a speech broadcast proudly to the world in September 2011, President George Bush of the United States described his determination to find and kill the enemies of the United States. We will find those who did it. We will smoke them out.
The President. Counsel, could you please hold on, and Mr. Co-Prosecutor, you may now proceed.
Thank you, Mr. President. Counsel has already been told to limit himself to the documents in this case. Now he's attempting to present evidence about speeches by other world leaders. This is not evidence that is part of this trial. I don't want to interfere in this presentation, but I think he is well exceeding the proper scope, permissible basis of responding to the documents that were presented by the co-prosecutors.
Mr. President, if I may reply, I'm not presenting evidence. I'm trying to picture a more general context. I'm quoting 4 lines of a speech that everybody in this courtroom, everybody in the world knows about. It's not evidence, it's a matter of general knowledge. I'll be giving some other quotes, 2 or 3 more, just to picture the broader context. It's not presenting any evidence.
The President. The objection by the co-prosecutor regarding the way the presentation is made is appropriate. Counsel is advised to present his position regarding how he would like to respond to the key documents on the facts presented in the case file, other than going beyond the scope as indicated.
I was merely trying, Mr. President, and I will not quote. I had some nice quotes for you, actually. I will not quote, but my attempt was merely to put it in a broader context. The policy of speaking by the CPK of internal and external enemies is exactly what the United States has been doing recently and in the Second World War, when, for instance, came to the internment of Japanese people in the U.S. It's a pity. Well, I will move on to the actual targeting of Lon Nol officials, Mr. President, Your Honors. And that is the alleged CPK policy to execute former soldiers and officials of the Lon Nol regime. As the Chamber knows, we vigorously dispute the existence of this supposed policy. And the more this Chamber hears of the prosecution's offer of proof, the more obvious it becomes that no real evidence exists, and that there was no policy. Now, we will spend quite a bit of time on this topic, so allow me, Mr. President, to give you a short roadmap of how my presentation will progress. It will have 3 parts. First, we are going to offer the Chamber some general observations about the limitations of the documentary evidence before the Chamber. This is, as you will, a general summary of the kinds of weaknesses we are seeing in these documents. Second, we will go through the documents that the prosecution presented. We will do this fairly thoroughly and try to show the Chamber how these general weaknesses apply across all of the evidence. And thirdly, we will talk a little bit about our own analysis of the witness statements on the case file. Witness statements quoted earlier by the prosecution. We will show that these statements are chronically unreliable, that they say nothing of substance, and indeed that in many ways they affirmatively disprove the co-prosecutor's claim that the CPK set out to target soldiers and officials of the Khmer Republic. Mr. President, permit me to begin with some general comments in respect of these documents. Now, sometimes the most important thing about the evidence in a case is what it does not include. What does the evidence not include in this case? The first thing it does not include, and we haven't heard that in the presentation, is a single piece of physical evidence that a single soldier was executed anywhere in Cambodia. There are no exhumed mass graves and no dead bodies. There's no forensic analysis. Now, this is not standard practice in a murder investigation. It is not standard practice at international courts. In Yugoslavia, investigators went out to the field, they dug up graves, they found bodies, all together in one place, and they were able to determine when those people were killed and how. Now, that is proof, that is evidence. The other thing the documentary evidence doesn't include is a single witness to a single execution of a single soldier. Now, we are going to talk about this in much greater detail later when we go through the evidence, the documentary evidence, and talk about those witness statements. But for now, Mr. President, let me give the Chamber this one takeaway conclusion. Not a single one of those witnesses witnessed a single killing. Now, even in an ordinary domestic murder investigation, the fact that there was no evidence of the time or place or method of death, and no eyewitness accounts would make a conviction nearly impossible. Our client is being accused of mass murder. Charges are serious, and the documentary evidence should logically be more plentiful and not less. And the standards that we apply in this courtroom should be at least as high. As defense lawyers, we have only one anxiety about the evidence that has been presented about the supposed policy to execute Lon Nol soldiers and officials. And it is not that the evidence is strong, it's that the documentary evidence is so weak. So weak that we have become accustomed to this in this courtroom. We fear that, to use an English expression, the prosecution is moving the goalposts. In other words, they are changing the standards by which these kinds of charges are usually judged. And we would urge the Chamber to guard against that. We would urge this Chamber to ensure that the documentary evidence is held to the high standard which the law requires. Now, I don't mean to say that a murder case cannot be circumstantial. It can be, if the evidence, of course, is strong enough. But the fact that there is literally no direct evidence of any kind is meaningful. It should make this Chamber insist that the circumstantial evidence on offer is especially compelling. With that in mind, I would like to call your attention, Mr. President, to a systematic flaw in that documentary evidence. It is in both the witness statements and the documents itself. And the flaw is that almost none of those documents presented by the prosecution say anything about killing. They talk about the alleged victims being, I quote, separated, taken away, arrested, sent to Ankara. But without any evidence that any of those people were killed, and there is none, those documents show nothing of relevance to this trial. This Chamber is being urged to conclude that because people were targeted, they must necessarily have been killed. But that inference, Mr. President, is far too aggressive, and it is not supported by the evidence. And on appeal, the aggression of that inference obviously will not stand. And there are numerous ways in which we can show the Chamber the danger of inferring murder merely from evidence of targeting. Now, if you allow me, let us look at 3 brief examples. One example is from a witness who testified recently before the Chamber. His name was Numuk. He testified on June 20. During the co-prosecutor's examination, Numuk described an instance.
Mr. President, Mr. Co-Prosecutor, you may now proceed.
I'm sorry to have to get on my feet again, Your Honors, but this is a point that I raised at the start, and counsel is, I believe, veering far from the purpose of this proceedings. We are going to have final arguments. Counsel is entitled in final arguments to address issues about burden of proof, to talk about the witness testimony. This is not the time to be making final closing arguments. And counsel is now attempting to read from part of the testimony of a witness and make overall comments about the burden of proof, which we strenuously disagree with, but more to the point is not part of the purpose of the current proceedings. So we would object to the use to counsel at this point, reading testimony, trial testimony, and making comments about that.
Mr. President, my intention was to paraphrase one or two sentences from this trial transcript. I'm not making any closing arguments. I'm just trying to establish the probative value of documents in relation to what one specific witness, because I only use one witness, has actually testified. So it's all about the context in respect to the probative value. I am not making an argument or closing argument about the value of Numuk. I'm just using him as a frame of reference in respect of the probative value of these particular documents. That's what I'm doing, nothing more.
The President, the objection by the co-prosecutor regarding the presentation by Counsel Koppe is appropriate. Counsel is now instructed to make sure that the observation is made relevant to the key documents presented by the other counsels rather than presenting the confession.
Very well, Mr. President. I intended to give you 4 examples, actually not 3, but 4 examples, showing the danger of inferring murder merely from evidence of targeting. I will now use only 3 examples. I will not speak about Numuk. My other example, my second example, is the following. And that is an example from a telegram the prosecution presented to this chamber. The document is E3/807. We will address the claim which the prosecution makes about this document soon. But for now, I would like to point the chamber to one sentence in this specific document. The document states, and I quote, "The children of soldiers, sub-district chiefs and police were purged and sent to do production in one place." Now what we are interested in is the word purge. Many documents, as you know, use the word purge. And typically the prosecution asks the chamber to interpret that word to mean execute. But obviously in this particular document it doesn't. Obviously it just means separate, because he can't be killed and then sent to do production. A third example, or now a second example, is from Philip Short's book, document E3/9. I'll quote from English, ERN 00396488. There is no Khmer translation, and my apologies that we don't have the French ERN right now. According to Short, during the evacuation of Phnom Penh, factory workers were separated from the general population. Short comments, when nothing further was heard from them, many deportees concluded that they had been killed. In fact, so says Short, most had been taken to Phnom Penh to help restore production in the factories where they had worked previously. And another example, Mr. President, is that one that we had already seen. And even the word smash does not always mean kill. And we showed that further up in our discussion of document E3/5. The limitations in this evidence are such that even if no contrary evidence existed, the chamber would be incapable of making the remarkable conclusion that a countrywide policy to execute all Khmer Republic soldiers and officials existed. But contrary evidence does exist. Prosecution's evidence is not just insufficient on its face. There are countless statements which show clearly that the party center explicitly instructed their troops and cadres not to execute soldiers. We are going to read some of those statements for you later in this morning, or probably this afternoon. There are statements from people who work directly with Nguyen Chia, Pol Pot, and others within the core of the party center. And these are people who were relied on repeatedly by the investigating judges in the closing order. They were relied on by the experts summoned by this chamber as key insider witnesses. And they say, no, Nguyen Chia and Pol Pot did not order the execution of the soldiers of the last regime. And there are other statements from soldiers in the field who state that their instructions were not to kill soldiers captured in the battle. Unlike the prosecution's systematically flawed documentary evidence, all of these statements contain first-hand evidence. All of them are from witnesses who were in the position to know the facts they are telling us. These were some general observations, Mr. President. Let me now begin to discuss the specific documents presented by the co-prosecutors. And let me begin that discussion by quoting some of the first words of that presentation. The co-prosecutors said the following, and this is at page 98 of the draft transcript for June 26. They said, and I quote, "Let me now turn to the documents that answer a question that Nguyen Chia's counsel has asked a number of times, which is, where are the documents that show the policy targeting Lon Nol officials and soldiers?" End of quote. Now, Mr. President Jonas, I have to admit that when I heard that, I got excited. I remember I was sitting here in this chair, and I think I even sat forward a little bit, and I suppose I was excited for a couple of reasons. One is just that it was good to find out that the prosecution had been listening to the Nguyen Chia defense team. We weren't sure of that before. But then they chose to spend a substantial part of their presentation of the documents about this alleged policy of targeting Lon Nol officials. And I realized, Mr. President, that we are actually on the same page. We're both concerned about whether any actual evidence of this policy exists. And the second reason I was excited is that I felt like we were about to hear something really interesting. Here was the prosecution telling us at long last, here are the documents that you have been waiting for. And it will not be a surprise, Mr. President, that if I admit that it was a bit of a letdown. Because then the co-prosecutors actually presented their documents. And as they came up on the screen, those documents failed completely and totally to give this court even a glimmer of evidence that anybody in the party center ever formulated a policy of any kind to execute former soldiers and officials of the Khmer Republic. Indeed, even the excerpts of the documents which the co-prosecutors quoted in court sometimes tend to establish that the party center did not intend to execute former officials of the Khmer Republic. To show that, Mr. President, I will now go through those documents in some detail, and I will follow the order of the prosecution's presentation. First, the prosecution presented two documents intended to show the ideological foundation of the supposed policy to execute Lon Nol officials. The first document was a 1974 issue of Revolutionary Youth. The document was E3/146. And the second was an October 1976 issue of Revolutionary Flag. And that document was E3/10. Let me first repeat, Mr. President, the observations I made earlier concerning with the prosecution's use of similar documents in connection with the so-called enemy's policy. It is apparent that these documents are manifestly inadequate to establish the existence of a concrete policy to execute specific people. They offer only the most general prescriptions about class divisions. The Chamber should take heed of the prosecution's use of these documents as an indication of how weak the overall body of documentary evidence must truly be. But even if we did accept this evidence on the prosecution's own terms, we would find that they have seriously misrepresented to the Chamber what it says. They have selectively quoted from it to badly distort its meaning. And we can only assume that the prosecution understands well how disproportionate the resources are on each side of this aisle, and are hoping that the defense teams have no time to verify these documents. The prosecution uses the first document, E3/146, for definitions of two types of classes: the feudalist aristocratic class and the intellectual second capitalist class. As the co-prosecutors rightly say, at ERN English 00538746, Khmer 00283409, and French 006118110, the document defines the feudalist aristocratic class to include the king and high-rank officials such as minister, provincial governor, and district governor down to the commune chief and chuntup. That's a clerk. The co-prosecutors then skip the next page. That's not surprising, since it says the following. I quote, "Our attitude towards these groups is that we have to persuade them to join the front, and then to eliminate their political stance and their old ideology by educating them continuously. But it is important that we redistribute land to them and have them do labor work to produce food to support themselves. End of quote. Further down in that same page, the document describes a different kind of feudalist class, which it calls the feudalist landowner class. And these include, and I quote, persons who own land and have their power to control land. End of quote. And then just one paragraph further down it states, and I quote again, we should not attack them constantly. We must know how to persuade them to join in the front rank. But we always have to be cautious with them. We should struggle with them to diminish their influence by reducing their rice paddy to as little as what the other peasants have. End of quote. Having skipped, Mr. President, Your Honor, this rather interesting page, the co-prosecutors then misrepresented the document even more egregiously by citing the definition of the intellectual second capitalist class, the intellectual second capitalist at English ERN 0053 8746, Khmer 00283409, and French 006118110. The co-prosecutors rightly say that this class includes, quote, students and civil servants who mainly use their intelligence for living, end of quote. But then they leave out the paragraph immediately before and the sentence immediately after. The fuller quote reads as follows. The second capitalist class. To speak conclusively, this is called the mediocre middle class. They do not oppress anyone, but they are not oppressed by anyone either. Their economic interest is mediocre, and so is their political interest. They live peacefully. Then it continues, there are two types of second capitalists. One, intellectual second capitalist. These include students and civil servants who mainly use their intelligence for living. Their important point is that they are patriotic. They love revolution and want to do the revolution because they, to some extent, are oppressed by the enemy. Another strong point is that they can understand and see the idea and theory quickly. But their weak points are, they are afraid of hardship. They want to stay peacefully alone, and they absorb the revolutionary line slowly. This is because they rarely received any hardship and were not badly oppressed by the enemy. End of quote. The prosecution's treatment of the second document, E310, Mr. President, was less dishonest. Not surprisingly, it also proves nothing pernicious. Indeed, it explicitly recognizes that capitalists and feudalists can reform. They can reform. It also explains that government officials, policemen, soldiers, and students were not themselves the instigators, but that when the capitalists and feudalists held power, they paid, I quote, they paid government agents to show their faces. End of quote. And the implication is, now that they do not hold power, they and not their agents are the targets. Next, the prosecution presented an excerpt from an interview given by Ing Sari in April 1978. The document number is E3/707. In the excerpt quoted by the prosecution, Ing Sari, and I quote, described the different forces within the Kampuchea ruling class at that time indicating three broad groupings. On the far right, there were those like Lon Nol, who were completely reactionary and nothing but lackeys of foreign imperialism. In the center stood Sihanouk, the head of state, and some others like him, who, while oppressing communism, also supported a policy of genuine political independence for the country. And on the left were progressive people like Khieu Samphan, today's president of the State Presidium, who at that time was a well-known intellectual and politician. End of quote. Your Honours, I could probably spend my whole day just talking about how little this one quote has to do with any allegation in this trial. Firstly, it is apparent that Ieng Sary is speaking here of the very highest ranking members of the Cambodian political class. He himself calls them the ruling class. Now, it says nothing about military officers, let alone ordinary soldiers. Second, it is once again a vague political analysis. It doesn't so much as hint that anybody, even Lon Nol himself, ought to be executed. Third, it is almost as if the prosecution forgets that Ieng Sary is describing a moment in time during which he was one of the leaders of a rebel movement fighting a civil war against Lon Nol. Does the prosecution expect Ieng Sary to complement Lon Nol's leadership skills? Under the circumstances, his language could be only described as mild. But fourth, and maybe most important, is there anyone in this courtroom that seriously doubt this analysis of Ieng Sary? Of course, Lon Nol was a client of the United States. Of course, he was bound to the United States. He was also exceptionally corrupt. Most of the evidence before this court shows that the wealthy merchant class in Phnom Penh, whom the prosecution would seek to place first on the list of enemies of the CPK, also hated Lon Nol. Ieng Sary's opposition to Lon Nol shows exactly nothing about the CPK attitude toward any segment of the population. There is only one interesting thing about this quote, which is that according to Ieng Sary, Sihanouk is not a right-wing reactionary, but a middle ground supporter of Cambodia's political independence. And by 1975, Sihanouk represented an infinitely larger segment of the population than Lon Nol. Lon Nol, Mr. President, didn't represent any segment of the population at all. Now, the prosecution quoted from one more section of this document, which I will reiterate as well for the chamber. And I quote, "We mobilized both the middle and left sections of the ruling class," said Sary, "and built a united front with them against foreign domination. We isolated the real traitors like Lon Nol." End of quote. Now, our last comments apply equally to this excerpt. It is hardly surprising or interesting that Ieng Sary described the leader of the government he was seeking to overthrow as a traitor. Lon Nol was giving his tacit permission to the United States to obliterate the Cambodian countryside using B-52 bombs. How many people in Cambodia in April 1975 did not see Lon Nol as a traitor? How many people did not believe that Lon Nol had forsaken Cambodia to the Americans? Did every person who thought Lon Nol was a traitor want to execute ordinary soldiers? The document, Mr. President, is absurd on its face. Next, the prosecution cited a series of documents describing messages sent by the Khmer Rouge in the last days of the war. I will list those documents quickly for the benefit of the Chamber. They are E3/783, /117, 334, 120, and E3/118. Now, most of these excerpts cited by the co-prosecutors repeat the call for the execution of the so-called 7 super traitors. And others describe other happenings during the final days before 17 April 1975. Firstly, Mr. President, let us deal once and for all with this question of the so-called 7 super traitors. Co-prosecutors insist on returning to this issue time and again. Yet the alleged crime itself is not within the scope of the trial. And the message which surrounded it was precisely that everyone other than the super traitors would be spared. So even if those communications cited by the prosecution do reflect an intent to kill those exact 7 people, they also show the opposite as to everyone else, including the alleged victim crimes who actually are at issue in this trial.
The President, Mr. Co-Prosecutor, you may now proceed.
Thank you, Mr. President. I will make an objection here. I've let a lot go. This is counsel's opportunity, but he continues to make rather serious misstatements in this proceeding about the scope of this trial. He's made many such misstatements already, but this one is important not to let go. There is no question, if he would read the closing order, that the executions of the 2 7 super traitors who remained in Phnom Penh is part of the scope of this trial. It is directly referenced and included in the charges relating to the First Force movement. And for counsel to stand up and make this representation is incorrect. This is his opportunity to address documents, but it is not an opportunity to mislead about the scope of this trial.
Mr. President, I think we have all read the closing order, and it's our position that the killing of these super traitors is not specifically part of the closing order. That's why we are making the argument. Of course, primarily we are making the argument that from the documents in respect of the killing of these 7 super traitors, no probative value can be deducted when it comes to the targeting and killing of, let's say, normal Lon Nol officials or soldiers. That is our position, and if the prosecution disagrees, that's fine, but this is our position.
The President. Counsel for Mr. Nguyen Chie, you may resume.
Thank you, Mr. President. My other point in respect of the 7 supertrader is that other sections of the quoted documents only reinforce our impression. The co-prosecutors quote from document E3/118 a statement on the Funk radio by Khieu Samphan. Describing the Lon Nol government leadership community on April 13, Khieu Samphan says, and I quote, "This Supreme Committee does not represent anyone but a few traitors. The creation of this organization is an anti-national and anti-popular act designed to continue the treachery of the last bunch of traitors. For this reason," Khieu Samphan says, "all brother countrymen in Phnom Penh and the few provincial capitals still under temporary enemy control should unite their strength and overturn this treacherous organization." End of quote. We believe that Khieu Samphan's message is very clear. All Cambodians should act together against a tiny group of leaders at the very highest level of the government. Most striking in this quote is Khieu Samphan's reference to, and I quote, "all brother countrymen in Phnom Penh," which definitely refutes the prosecution's claim that city dwellers were treated as enemies in April 1975. Those brother countrymen included any officials of the former regime outside of the Supreme Committee. Mr. President, the next group of documents continue on this general theme. They too all concern this very small group of individuals at the very top of the Lon Nol regime in Phnom Penh. Document numbers are E3/2694, E3/2700, E3/2702, D365/1139, and E3/604. The first 3 documents are communications from Jean Dirac, the ranking diplomat in the French embassy. And the final 2 documents are articles from the Washington Post and the Bangkok Post, respectively. All 5 documents combined purport to describe only 3 executions. 2 of the 7 supertraitors and Lon Nol's brother. Jean Dirac's telegrams say that 100 people were expected to surrender as prisoners to the Khmer Rouge the following day as prisoners. There's no evidence of who those people were, and there's no evidence from this document of what happened to those people. The next document, Mr. President, Your Honours, we readily admit is arguably the best piece of evidence the prosecution came up with. It is an execution order from Comrade Pin, and it is document number E3/832. It is at least nominally relevant, which by itself sets it apart from the rest of the documents presented by the prosecutors. And if it were the 15th or 20th piece of evidence, it might even be compelling. But all this document shows is that an order was delivered by Comrade Pin to somebody to execute 17 specific people. It does not show who the order came from or to whom it was delivered. The fact that the order ostensibly came from, quote, the party, proves, of course, nothing. The Chamber has heard testimony that cadres at all levels used the label Ankar opportunistically to exercise their own petty authority. Pin's use of the phrase, quote, the party, does not mean anything literal, including that he was implementing an order from a superior. The document also clearly shows that whoever did decide to execute these 17 people, if indeed someone did, it was not because of their military position. Because the document specifically states the alleged victims were, and I quote, examined, unquote, before a decision to execute them was made. Now, if a policy to execute all soldiers or all officers existed, there would be no need to examine any of them. Next on the document to certain names, there are additional indications that each person's loyalty was assessed. Next to number 14, for instance, Iam Sai, the document states the following, and I quote, "He is a former teacher who was a traitor when he was a teacher. In his biography, he criticizes us very strongly, using psychological warfare. His responses show absolute support for the Republic regime and opposition to the revolution." I'm referring, Mr. President, to ERN English 000-68919 and Khmer 0068916. And there the order also lists 2 other senior military officers and a sub-district chief, noting, and I quote, "Please keep for examination the following named persons." End of quote. Now that alone proves that even senior military officers were not executed as a matter of policy. Next, the prosecution presented a 21 May 1976 news report from Agence France Presse that 54 former generals were executed shortly after 17 April 1975. In general, Mr. President, the prosecution's continued reliance on news sources should again be an indicator to the Chamber of the overall weakness of its documentary evidence. But this document is especially unreliable and has no probative value whatsoever and should be disregarded completely. Neither the journalist nor the unnamed quote-unquote resistance spokesman who acts as the sole source is known. Even the description of the source as a resistance spokesman is confusing. Resistance to whom? The resistance faction against Pol Pot? If so, isn't the claim transparent anti-Khmer Rouge propaganda, is the question. Now the article, Mr. President, Your Honor, is even more unreliable because on the substance it makes absolutely no sense. It claims that the list of generals was, and I quote, "sent to several Western governments," unquote. Now why why would the CPK execute 54 people and then announce to the world that they had done it? And if they did want to announce it to the world, why would they quietly send the message to Western governments and not bluster about it in the revolutionary flag, as they did with the 7 super traitors? If it was disclosed to several governments, why isn't there any evidence from any other source aside from this single news report from a single journalist? Why did the CPK suddenly decide to reveal the executions 13 months after they happened? Why did they draw up a list in December 1975, 7 months after it happened? And how did they contact Western governments without any direct diplomatic relations? None of this, Mr. President Jonas, makes any sense. Next, the co-prosecutors discussed 2 biographies prepared by cadres of the Ministry of Foreign Affairs. Those document numbers are E3/3569 and E3/128. To us, it is apparent that these documents mean absolutely nothing. So I will spend no time on them. I will only say now today that they make no mention of any execution or even ill treatment of anyone. Next, Mr. President, the co-prosecutor supplied 3 different S-21 prisoner lists. Now, before we look at these specific documents, allow me to make an obvious point. Many different kinds of people are alleged to have gone to S-21. According to the closing order, the total number of Lon Nol soldiers allegedly killed at S-21 is 328. Now, if our math is correct, that makes 2.5% of the total of 12,000 prisoners. Is that a lot? Was the Lon Nol army more or less than 2.5% of the population? The prosecution does not say. So we just know these people were apparently Lon Nol soldiers. But from this document, there is no evidence that any of them were sent to S-21 because they were Lon Nol soldiers. There is no evidence that any one person went to S-21 because they were in the Lon Nol army. Let us now look at the specific documents the co-prosecutors presented. If we look at these documents carefully, we will see that the first document proves the opposite of what the co-prosecutors say it proves. It shows that no policy of executing Lon Nol officials existed. And the other 2 documents prove nothing at all. They have no probative value whatsoever. The first document, Mr. President, is number E3/1539. Now, it claims that in 1 month, in March 1976, 162 Lon Nol officials and soldiers were killed at S-21. If in fact 162 Lon Nol soldiers were killed in March 1976, that only means they were not killed for almost a whole year. If there had been a policy to execute all Lon Nol soldiers, they would have been killed, most likely, 11 months earlier. Also, the fact that from these documents it seems to appear that many soldiers were sent to S-21 all at once strongly suggests that they were executed not because they were Lon Nol soldiers, but for some other more specific reason. Obviously, something happened in March 1976, but we don't know what that is. But it isn't that the CPK suddenly decided to kill all Lon Nol soldiers. The second document is E3/2189. The co-prosecutors say that this document shows an effort to target Lon Nol officials because the title of the document is, and I quote, "Prisoners who were government officials," end of quote. According to the OCP, and I'm quoting them now, the very title that was given by S-21 to this list reflects the targeting of government officials or civil servants. The prosecution, however, did not show this document on the screen. We think we know why, because it contains a total of 6 names. We do not know why this document carries the title that it does, but it is obvious it says nothing about any alleged policy. And if it does, then it would be a very limited policy. The third document was E3/3597. Some of the people on this list are alleged to have been former soldiers and officials, and some are not. But the prosecution does not tell us how many of each. Nor is there any reason to believe that any of these people were sent to S-21 because of their former position in the government. It is also irrelevant. The co-prosecutors then presented the minutes of a standing committee meeting concerning the royal family. That is document number E3/197. Again, it says nothing of any executions or any kind of executions about the Lon Nol government or about the Lon Nol government as such. And therefore it is completely irrelevant and misses any probative value. Then the co-prosecutors presented 3 military communications. All 3 documents are once again irrelevant. The documents are E3/1162, E3/183, and E3/807. All these documents show is that in these particular units, soldiers were monitored to see if they had any connection or loyalty to the last regime, which is reasonable enough and certainly not out of the ordinary in a new revolutionary state. I wanted to quote you something about every person of Japanese ethnicity who was held for 4 years in internment camps in the US during World War II, but I wasn't allowed to do so. But here you see the direct relatives of people who actively fought against the CPK, treated a little bit differently from the rest of the population. Your Honours, what is the prosecution's point when it comes to these documents? We, at least, have no idea. The next 2 sets of documents presented by the co-prosecutors were a group of records from the Tram cooperatives and then 3 witness statements. We acknowledge that the prosecution described those witness statements as a sample of what they claim to be a larger group. Mr. President, as we indicated earlier this morning, we plan to present our own discussion of the witness statements. And the three statements that the co-prosecutors presented are part of that discussion. And the Trump-Cock records also relate to those statements. But I will, if it pleases the Chamber, I'll put those documents aside for now and move on to the co-prosecutor's last few documents. And I would say that it would be an appropriate moment, Mr. President, to have the lunch break.
Mr. President, thank you, Council. It is appropriate moment for lunch adjournment. The Chamber will adjourn until 1:30 p.m. Security personnel are now directed to bring Mr. Kilsampon to his holding cell and have him returned to the courtroom by 1:30 p.m. The court is adjourned.
សូមក្រោកឈរ